This video is about the ethical aspects of using LinkedIn. LinkedIn, as you know, is the largest professional network in the world, and it offers many opportunities for lawyers. But at the same time, there are a number of ethical issues and challenges that lawyers need to be aware of. And that's what I want to discuss in this video. Broadly speaking, they fall into 5 different categories. First is the possibility that participation in LinkedIn can be considered to be advertising under the rules of the jurisdiction in which the lawyer is practicing. Secondly, relates to issues involving use of the terms skills and expertise, which is the categories that LinkedIn uses. Thirdly, use of LinkedIn with reference to results obtained in representation. Fourth, testimonials and recommendations. And finally, comparisons with other lawyers. So there are a number of ethical issues, and a first issue for lawyers to think about is how to deal with these potential problems and risks associated with the use of LinkedIn. And of course, one answer is simply to say, I don't want to run the risk. I'm just not going to participate in LinkedIn. It's the prudent and the safe course to follow. And that's a rational choice for a lawyer to make, although it means that the lawyer is foregoing one of the most predominant and potentially most effective social media networks available to the lawyer. So suppose you've made the choice that you do want to participate in LinkedIn if it's at all possible to do so consistent with ethical obligations. How can you do so? Can you do so? And in my opinion, the answer is yes, provided you effectively use disclaimers. So let's think about the different problems that you face. One problem is that in some jurisdictions, LinkedIn might be considered to be lawyer advertising. And in fact, I think that's probably a proper characterization of it, because the purpose of LinkedIn is to create professional networks. These are not social networks. And they're done for the purpose of generating income. They are economic in nature. So I think they're properly treated as advertising. That means in the jurisdiction in which you practice, it may be necessary to file your LinkedIn profile. That shouldn't be a particularly burdensome matter so long as the jurisdiction doesn't require unduly hampering the use of LinkedIn by having excessive filings. And I think what that amounts to is if there is any significant change to your LinkedIn profile, that you should file it if the jurisdiction is treating LinkedIn as an advertisement subject to filing. The second topic deals with skills and expertise. In some jurisdictions, you cannot use terms like specialist or expertise. The limitation on those terms is typically designed to protect the integrity of the jurisdiction's specialization licensing system. So how can a lawyer participate in LinkedIn which uses the term expertise when the jurisdiction prohibits the use of such terms? One possibility, of course, is simply not to list any skills or expertise. But again, that dramatically limits the usefulness of LinkedIn. In my opinion, it should be sufficient to use an appropriate disclaimer in your profile. And LinkedIn allows you to develop your profile to indicate background information and so on, but you can also use the profile to put appropriate disclaimers. So consider, for example, this disclaimer with regard to the use of the term specialist or expert, and this is the disclaimer I use on my LinkedIn site. Some jurisdictions forbid the use of the terms specialist or expert or similar terms. Entries in this profile, and in particular under skills and expertise, are not intended to suggest any such status in violation of the applicable ethics rules. LinkedIn simply doesn't allow you to avoid the use of those terms except by simply not listing any skills or expertise. it seems to me that it should be sufficient, recognizing the limitations that LinkedIn has, to use a disclaimer of this type. And I hope bar authorities will so consider the use of a disclaimer. The same thing can be said with results obtained. The typical ethics rules state that if you are going to advertise or communicate about results that you've obtained, you've got to make a disclaimer that past results are no guarantee of future results. And again, in your LinkedIn profile, I think you can do this. For example, prior results do not guarantee a similar outcome. And I think that should be a sufficient disclaimer, unless the jurisdiction requires the use of a particular language for the disclaimer. Testimonials are a particular problem with LinkedIn. LinkedIn has developed this system of endorsements or testimonials, typically from other lawyers, although they can come from clients. And they create problems depending on the ethics rules in question. For example, in South Carolina, where I practice, we have a rule that says you cannot have a testimonial or endorsement of the lawyer, quote, which is not made by an actual client without identifying that fact. So suppose the endorsement or testimonial is made by a lawyer who is not an actual client of yours. How can you deal with that on LinkedIn? Well, one possibility, of course, is simply not to accept the endorsement, and LinkedIn allows you not to accept the endorsement. That effectively means that you are eliminating the endorsement component of LinkedIn, which is a very useful way of indicating that you practice in certain areas. Once again, in my opinion, I think a disclaimer on the profile should be sufficient to deal with this problem. Let me give you an example of the one I use on my LinkedIn profile. I may be endorsed by both professionals and clients. Rules in some jurisdictions require endorsements to indicate whether the endorser is not a client. Because LinkedIn does not provide a method for such a designation, consider every endorsement as not being made by a client. That accommodates the acceptance of endorsement to the South Carolina rules. Now, in other jurisdictions, there may be more restrictive rules dealing with testimonials. For example, the Florida rules are even more restrictive on the use of testimonials. Under the Florida rules, in order to have a testimonial, it must be the actual experience of the person giving the testimonial. I think it's aimed at making sure that it's an actual client. But the result of that may be that lawyers that you don't know that well may be giving a testimonial that is not based upon your actual experience, but is merely based upon your reputation. Does that mean that a Florida lawyer could not use the endorsement portion of LinkedIn? Perhaps so. But in my opinion, again, I think the bar authorities ought to be flexible enough to allow lawyers to use a profile or to use LinkedIn with an appropriate disclaimer. And I think the language of the disclaimer could be drafted in to deal with the Florida language of its rule on testimonials. So in the case of the language I was given earlier, you could say in Florida, whether the endorser is not a client or has the actual experience with the lawyer in question. The fifth area in which there can be a problem with the use of LinkedIn is by the use of comparisons. In some jurisdictions, you can't compare your services with the services of other lawyers unless it can be factually substantiated. Again, in my opinion, it should be sufficient to have an appropriate disclaimer in the profile site. And of course, you would want to avoid making any kind of comparison statements, but as an added protection and as an added step of compliance with the rules, you could have language like the following. Any statements in this profile are not intended as a comparison with the services of other lawyers or law firms. Any statements referring to my services are only intended to refer to my experience. So, to conclude, there are a number of ethical problems with the use of LinkedIn, particularly with regard to the testimonial and endorsement aspect of LinkedIn. But I think they can be dealt with by an appropriate disclaimer. I do want to mention one other aspect of testimonials, and that is it's not at all uncommon that you will get testimonials with regard to areas in which you do not feel that you have any experience or any degree of competency. How should a lawyer deal with those? In my opinion, the way to deal with those is simply by not accepting the endorsement. I think it would be misleading for a lawyer to accept an endorsement in areas in which the lawyer doesn't practice and doesn't have experience. And I don't think it's necessary to accept such endorsements in order to have a full participation in LinkedIn. So, in most instances, a disclaimer will be sufficient, but in other instances, use of the proper language or proper conduct to avoid engaging in misrepresentation is called for, and this is one of them. So in conclusion, LinkedIn is an important tool for lawyers in the modern professional world. I think lawyers should be able to participate in LinkedIn. I think accommodating LinkedIn to the rules of professional conduct causes some tensions. I think if bar authorities are appropriately flexible, these tensions can be resolved principally through the use of disclaimers.